Yeah, he alleges. Exactly what he's supposed to do in a complaint is allege something plausible. Okay? That's all. A plausible allegation. You don't think it's a plausible allegation that somebody on YouTube could take somebody else's content and manipulate it and maliciously in a way that might be against slander and libel, and that might eliminate their option of using the fair use exemption to my ownership. Okay? Fair use is an exemption to copyright law. All right? That's what it is. And so and that's the limitation. It's an exemption. And you don't get the exemption for any kind of behavior. You get the exemption for certain kinds of use. It's called fair use. It's not called slanderous use. Any fucking use you choose use. Oh, you dumb bastard. Fucking professor. No wonder why you're a professor of, ignorant dead culture. Because you're an ignorant dead fucking bastard. Brain dead.
Facts supporting these claims. Instead, MELINDA provides a list of several YouTube channels where his videos, as well as those of some...
Again, I did exactly what you said didn't happen, and she didn't prove that it didn't happen. She didn't quote my complaint and point out how it was deficient, how this sentence does not describe something, how this sentence does not describe something. She didn't do that. She just makes some blatant statement. I don't understand it. I don't know what is libel, what is copyright. I don't know what any of these things are. It's bullshit.
The defendants in this case are busted, even with the liberal pleading standards applied to the claims of pro se litigants. MELINDA fails to plead either a claim for copyright violation or libel. Therefore, these claims must be dismissed.
You know what the state standard is here? For this kind of crap? The state standard is the judge's obligation is to do an exhaustive search. They're supposed to exhaustively search the complaint to find a violation or a possible law violation. That's what they're supposed to do before they dismiss a case. It's exhaustively search for a way that circumstance could equal a crime. And that's their obligation. It's exactly the opposite of what you're implying. And that's the standard, Remy. Okay, you do not dismiss cases unless you are certain there is no possibility that the law got violated. That's the word plausible, turn it into implausible. That's the standard. The standard is you have to basically demonstrate that the cause of action is implausible, that it's implausible a law was violated, that's implausible that this circumstance creates an environment where a law could have been violated, the law you're pointing to. That's the standard of proof, you dumb fuck. I mean, for a complaint. All right? Again, all this crap does is eventually, like I said, everybody's going to file 40-page complaints. All right? And it's going to be a lawyer's game again, okay? Because who the fuck but lawyers are going to have time to compile all their evidence before they file the goddamn complaint? Nobody's going to fucking do that. All right? That's bullshit. It's never been the standard. You prove your case when you get to goddamn court. And that's what summary judgment exists for. I mean, I could lecture you on the law forever. But the very point of summary judgment, its very purpose is to fix this problem you complain of. That's what it exists for. If you believe what the person is saying couldn't have possibly been a violation of law and that you didn't violate the law, then you demonstrate your proof that you're innocent. And Joneser didn't even come close to doing that. He didn't cite any case law on the subject of copyright law to demonstrate that anybody is allowed to do anything they want with goddamn other people's material. Quite the contrary. He made just completely ludicrous, nonsensical arguments implying that somehow, because he's an anonymous character, he can do whatever the fuck he wants.
By the way, I don't think that's entirely accurate sentence. She says you failed to provide a single fact. I think, in fact, you provided one single fact in your complaint.
No, it's a fact. I provide the fact that he has a YouTube account, okay? Right there provides means, all right? Doesn't it? Doesn't that provide means? So that's like saying O.J. had a Bronco and could get to Nicole's house. All right, then I provide another fact, and I talk about the fact that I make content, that they took my content. That's the allegation. That's quite plausible that somebody can do that on YouTube. There's no prohibition against somebody stealing somebody's content and doing whatever the fuck they want with it. Again, plausible cause has been demonstrated, asshole.
And I'll pressure that here in a minute, but so what she's doing is saying that you just did not provide a sufficient claim that a cause of action existed to go forward. And let me just say for the benefit of people who might be listening and don't know much about this sort of arcane legal stuff. And by the way, I'm not a lawyer, you're not a lawyer. So what we are a pair of amateurs kind of talking about what is up. Yeah, well, lawyers talk about this shit, and judges talk about this shit. Most of the judges that end up in the Supreme Court when they talk about it are kind of pissed off. Okay, because they keep trying to say that, yeah, you gotta, you can't be fucking with people's complaints, and you only dismiss complaints when you're damn sure. And what's happening, though, is a bunch of small people their litigation is being routinely destroyed by judges who are imposing this ludicrous definition of yours or some other bullshit, just some accusation they make, and the people they're doing it to just don't have the capacity to go to an appeal court and make the damn argument, okay? It's only because I had the balls to do that I saved this fucking litigation the first time. It's because I had the balls to do it again, I'm going to save it a second time, even if I have to take it to the fucking Supreme Court, because this is complete bullshit. The complaint is completely understandable. What I'm stating, what law was violated, is completely understandable. All issues of plausibility has been demonstrated, and on top of that, I have offered to provide DVDs with every fucking video I possess, every comment Joneser makes. If they want more evidence of the crime, I'll give them all the fucking evidence they goddamn want. But that's not how you prosecute a goddamn complaint. That's not how you play the fucking game. Obviously, a very technical field where precedents and case law covered. But let me get my understanding of how this goes. A case is initiated by complaint, and what a complaint has to do is establish a cause of action. cause of
Then why don't you just read it? You know, a short, plain statement establishing two things: what law was violated, and some explanation of how the law was violated and how you were harmed.
There's an argument that some substantive right that the plaintiff has been violated by the defendant, and that argument has to be strong enough.
It doesn't have to be anything about a goddamn right, Remy. It's about a law being violated. Okay, I'm civilly prosecuting, just like a prosecutor will prosecute somebody for trespassing or whatever they're going to prosecute him for. I'm prosecuting somebody for a fucking crime. All right, I have evidence of the crime. When I make the complaint against them, I just say, yeah, we got you, fucker. We know that on a certain date you were at a certain place and you did a certain thing, so you're cooked.
Convincing enough to support going forward with the hassle, the expense, and the risk of a trial. And a cause of action consists of two things. First,
again, you've misstated it, okay? There's lots of procedures in between going to trial and a complaint. And through those procedures, you can judge the gravity, the substance of the possibility for success. And the only way a complaint is supposed to be dismissed if there's no possibility of success. And that argument cannot be made without arguing copyright law and slander and libel law, without arguing case law. You just can't do it. I could make the accusation that he said the word, he called me a farthead. Theoretically, there's no reason why that shouldn't be allowed to be stated, and then he'd have to do a summary judgment motion to say nobody in the history of mankind has been sued for libel over calling somebody a farthead. Damn it. But that's the procedure, you asshole. This is the way they undo the procedure. This is how they break justice. This is how they make justice. And that's why judges even say this is the third rail. This is a low probability of success if a judge chooses this tact. Okay, on appeal. These cases fail routinely on appeal. These dismissals.
Well, it consists of a factual scenario. The plaintiff has to lay out a set of facts, A, B, C, D, defendant A, B, C, D, E, etc., etc. And then on the basis of those facts, it has to draw conclusions that some substantive...
It's not just facts, it's factual allegations, okay? Allegations of fact. That's what I had in my complaint. Allegations of fact, okay? That it is a fact that they took, that they have YouTube accounts, that they took my content without permission, and that they did it in violation of both copyright law and libel and slander law.
Violation of rights has taken place. And those two are distinct. Those two elements of the cause of action are distinct. There has to be a factual scenario that's laid out, and the conclusions have to be drawn. And,
wrong. Like I said, all you do is make a plausible allegation, right? It used to be just a possible allegation, and now the standard is plausible. And I made a plausible allegation.
In reviewing your complaint, what the judge did was to essentially compare the cause of action that you laid out in your complaint to a couple of legal standards that she cites.
Right, and the two cases she cited, and part of the two, the others are different cases, different circumstances. Of course, each case has its own nuance, okay? If you read those cases are about very complex allegations being made that are very close to basically somebody walking into court and saying, I know George Bush is a Martian. If we go and investigate him and we peel his skin off, I'm sure we'll find out he's a Martian. I mean, they were completely fishing expedition complaints, all right? And so the court found a rationalization it could use to basically say, well, look, we know it's possible in the sphere of imagination and such that somebody might be able to say that, George Bush is a Martian. But it's realistically not possible. So now they've come up with a way of saying there's this element of realisticness that has to be attached to this claim. And it can't be completely preposterous. So it has to be something plausible. We use the word plausible. But that's how the word was used, Remy. That's the case law it's from. That's the context it's from. It was not invented, this new standard, based on a simple copyright claim or a simple claim of libel. Those cases don't have any of that nuance. They don't have any of that kind of complexity. It's going to be a simple issue of law. Did the statements match what the law requires? And is the law applicable? And I've demonstrated, I've made clear allegations defending the plausibility that this crime did take place and that the law was violated. It's not that fucking complicated. You goddamn know it. You're just playing goddamn mental gymnastics games just like the motherfucking judge, just because you're a petty fucking weasel.
And these are the Twombly and the Iqbal cases, both fairly recent case law. Twombly is 07. Iqbal, I think, came out in 09. And my understanding is that what these two standards did essentially was tighten up a bit the rules for filing complaints. The bias in reviewing a complaint is in favor of the plaintiff, obviously. The plaintiff doesn't have to lay out his entire case in minute detail. What he has to do is establish a cause of action. And courts are
yeah, right. It's not even minute detail. It doesn't have to establish the complaint is supposed to be a simple, plain, simple. Yeah, that's the word. Simple, plain statement. That's the goddamn law, Remy. It's not supposed to be any big, long description of a big, long. Here's my evidence. This is what we suspect. We're going to have this guy testify. None of that shit is in a complaint. It's not supposed to be.
Favorably on these complaints. You don't want to throw somebody's case out of court before his claims have even been validated or tested.
And right, so mine obviously aren't validated or tested, and they've been pointed to so fucking directly that validation is easy. Is it possible for somebody to violate copyright on a YouTube video? I mean, that's an easy question. Is it possible that calling somebody an anti-Semite or putting them in Hitler drag is slanderous or libelous? I mean, come on, Remy. Yeah, it's real plausible, goddammit. So fucking plausible that's incredible. Is it plausible that some guy who would say somebody files frivolous lawsuits, even in his fucking legal papers, and make outrageous accusations that he's filed 60 cases that were overturned in the New Jersey courts or some other bullshit accusation? Is it possible that this reckless lunatic could fucking possibly violate libel and slander law or possibly trespass on somebody's copyright? Oh, fucking yes, it's quite fucking plausible, Remy, you dumb fucking asshole, and you goddamn fucking know it.
But, as I understand it, the standard for complaints has just gotten very low. A lot of complaints will be filed sloppy and vague. And so these two decisions.
Where did you find that, exactly? Where did you find that? That has never been the problem. It's never really been a huge problem because judges have lots of vehicles to get rid of that. Judges can initiate a summary judgment motion. Judges can initiate a dismissal motion. And they can provide real hard evidence, real hard explanations and descriptions of why it is impossible that somebody's claim could be valid. That's what they do. They explain why it's invalid. They don't just sit there and say it's invalid. That's what this judge did, which is completely outrageous. If you are going to claim it's invalid, you have to explain why it is not